My name is Brig Daniels. I am co-director of the Wallace Stegner Center with my wonderful colleague, Lincoln Davies. I'd like to start today just by reading our Natives Land Acknowledgement. We acknowledge that this land, which is named for the Ute tribe, is the traditional and ancestral homeland of the Shoshone, Paiute, Goshute, and Ute tribes. The University of Utah recognizes and respects the enduring relationship that exists between many indigenous peoples and their traditional homelands. We respect the sovereign relationship between tribes, states, and the federal government, and we affirm that the University of Utah's commitment to a partnership with Native nations and with urban Indian communities through research, education, community outreach activities. Just a couple of announcements before we begin. Number one, the Wallace Stegner's annual symposium, our 31st, will be held on March 19 and 20. The topic that we'll be addressing is America's public lands at a crossroads. Registration is open right now. We really do encourage you to reserve your spot and join us for the two-day discussion. I think we'll be discussing a lot about a lot of the controversies that we're seeing right now on our public lands and what can be done to preserve some of the most important and scenic places in our country. We will also be considering the very dramatic shifts in law and policy that have been ongoing over the last few years, as well as diverse challenges to the West, ranging from wildfires to climate change. Also, please keep your eyes open on the Stegner online calendar, which has the symposium details, but also other links that will be updated from time to time. Today's green bag is a talk, Does Recognition Reduce Pollution? Evidence from Environmental Remediation Liabilities by Sarah Malik. She is assistant professor at the University of Utah's David Eccles School of Business and an IZA research affiliate. She is one of the most promising young scholars that we have on our campus, and we're thrilled to have her here with us today. Just to give you a brief bio, she graduated from Stanford Business School in 2021 with a PhD in business. She has done a lot of work with Cornerstone Research, an economic consulting firm, for 5 years. You're going to see here off to the side, if you want to ask a question, we ask that you go to slido.com. That's slido.com. In the question space or the hashtag space, please write in after the hashtag write Stegner. After that, you'll see the list of questions that will be growing as she speaks. At the end of the talk, I will be moderating those comments and providing them to our speaker. You also, as viewers, either here in the room or online, if you go to slido.com, hashtag Stegner, you can not only ask questions, but you can upvote your favorite questions. I would also just, before I introduce Sarah, I would just like to I'd just like to thank the Cultural Vision 30 Years Endowment Fund, which provides support for a variety of Stegner programs, including our annual symposium for our Young Scholar Lecture, and importantly here, our Green Bag series. Please join me in welcoming Professor Sarah Malik. Professor Malik.
Hi, everybody. I'm really delighted to be here. Thank you to everyone who's attending in person. Thank you to everybody online. And to the Stegner Center, truly very excited. And thank you also for the introduction. So I've been doing some recent work on environmental pollutants and market mechanisms to reduce them. And in today's talk, my objective is to kind of introduce you to the economist perspective on this and how economists think about this, the intersection between the market solution and maybe a legal solution. Talk about other work done by scholars, and then towards the middle and the end, I'll introduce my own most recent working paper. And look forward to your questions. And also, again, thank you for the introduction. Normally, whenever I present a slide or do any kind of presentation, I talk about who I am. Brig covered all of that, but this is all to say I am not a lawyer. I've never been trained as an attorney of any kind. I've just been kind of law adjacent. So please forgive any abuse of notation or terms, and please correct me so that I can better myself in this. But I will say that I'm a little unusual, I think, in terms of the presenters that you have come to this series, and that I'm not just a lawyer, I'm an accounting professor. And let me tell you, that does not get people started at the party when you tell them that you're an accounting professor. But I'm hoping that today I convince you otherwise. When I say accounting professor, what I really mean is that I'm a scholar who studies information economics. And what this presentation is going to be about is when information about pollutants is provided to the market, what do market participants do, and to what extent are they disciplining firms and encouraging those firms to reduce their pollutive output? That's where we're going. So the two big things that I'm hoping that we can talk about today, the first of which is let's quantify whether and to what extent capital market forces, and by that I mean like market forces in like the stock market, for example, can achieve environmental compliance objectives. And then I also want to highlight the complementarity between, and I know this is good, don't let this put you to sleep, but accounting rules, what I think of as like a form of financial regulation, and environmental law. So with that in mind, let's get started. So I'm an economist by training, and I want to talk about what governs firms' pollutive output. And I think the simplest way to think about this is that you can have two regimes, two frameworks, and this is, again, a simplistic kind of purist perspective, but the way I imagine it, and my colleagues would imagine it, is that you have a legal framework, and then you have a market framework. And then the legal framework, a great example of this is something like command and control, where you just simply ban the use of some kind of pollutant, right? And what matters are the following three dimensions: the price of the bad behavior, the enforcement and the remedies, and the information provision. So the price of the bad behavior in a legal framework where it's command and control could be, okay, if you do emit this pollutant, you're gonna have to pay a fine. It may be on a per incident basis, whatever it is, that's the price. The enforcement and remedies identifies who's responsible for ensuring compliance with this, what remedies they can seek, if there's private right of action, for example. Again, I'm still learning about what you all do as lawyers, but that's my understanding. And then the information provision, in many cases, and what we're going to focus on specifically today, is that the law specifies what information must be provided to a counterparty, under what time frame, the granularity of that information, all of that. On the other side, and this is what I am much more familiar with, is the market framework. So let's imagine a world where it's just strictly two counterparties bargaining, and all of what we see are bargained outcomes. In that case, a good example of this would be, imagine that you had an institutional block holder coming in and buying up a large portion of a public firm. It doesn't have to be public, but we'll start with that. Well, and let's say this institutional investor has non-pecuniary preferences, that is, they want to reduce pollutive output. Well, they're going to put a price on the bad behavior by the firm. They're going to say, well, if you pollute more, I'm not going to buy the company at such a high share price, for example. There are really no enforcement or remedies. Everything's through like counterparty risk and contracting. And then the information provision is itself a bargained outcome. So it's like, I'm going to the counterparty, I'm the institutional holder, I'm going to buy 20% of the outstanding shares on the market, and this is the information that I need from you to do this purchase. Now this again is this again is a very simplistic way of thinking about, excuse me one moment. Very simplistic way of thinking about it. And what I'm going to talk to you about with my research is that rather than thinking about the legal framework and the market framework as two distinct entities, I'd rather we think about them as a spectrum. And this red box over here represents not just my research, but the research that a lot of economists are doing. And those previous parameters that we were talking about, in this case, some of them are defined by the legal framework, and then the rest is left up to the market. So what I'm going to talk to you about today, the enforcement and the remedies, All of that is set up by a legal framework. The information provision is determined by the laws. And what happens is that using that information, the market comes up with a price for bad behavior, in this case pollutants, and then that informs the ultimate level of pollutive output. Okay, so again, this red box represents where the legal framework and the market framework jointly determine environmental performance. And a mixed strategy is typically a great thing, right? Because either if you go purely on a legal framework or purely in the market framework, it's going to be an incomplete solution. So the market framework cannot address externalities that exist in the market, and the legal framework is not necessarily built for efficiency. So the argument I'm going to make today in my presentation is that this area of where you have half legal, half market attempts to regulate pollutive output by firms is quite effective. It's not perfect. And so what I want to talk to you about today is how effective it has been and what are some of the ways we could make it more effective moving forward. How can we deliver the maximum results? So in order to talk about this, we're actually going to go back to what sounds like prehistoric times. We're going to go back to the 1990s. And in the 1990s, we're specifically going to talk about toxic releases. I'm going to apologies if this is some stuff that you're already familiar with, but I just make sure we're on the same page and we can discuss this. The US government has, since I think the 1980s, and even before that, but most concretely in the 1980s, regulated the generation, transportation, storage, disposal of hazardous materials, where hazardous materials is very specifically defined. But it also has the authority to demand cleanup of contaminated sites at the expense of the emitting entity. And there are a number of laws that, to the best of my knowledge, kind of govern this space. The Resource Conservation and Recovery Act of 76, CERCLA of 80, SARA of 86, not to be confused with SARA of 88, that's me. Various state laws that can exist on the books. And to be very clear, hazardous waste is a legal definition. It's not toxic waste, but I'm going to be using the terms interchangeably here for now because there is significant overlap. But the idea here is that firms are not allowed to emit without consequence. If they contaminate a site, it can create a legal liability. And the question is the market going to penalize them for that legal liability? Well, the first thing that was required for the market to penalize them, again, for an investor to say, hey, I'm not happy with the amount that you're emitting, is that the investor needs to know. And so what I want to introduce you to is the first set of market-based regulations that was meant to curb environmental or pollutive output. And this is the TRI program. I don't know how many of you are familiar with this. Again, apologies if we're going to be talking about it at large, but this is an incredibly powerful legal regime that started in the late 80s and persists until today and governs how much information is available to investors about the toxic releases by an entity. And economists discuss this idea of just putting knowledge out there into the market and then letting other people decide, letting investors, letting non-investor stakeholders, whomever they are, decide how problematic that is. This concept is called revelation as regulation. Put the information out there, let everybody else decide what is acceptable and what's not acceptable. So this is when I'm talking about that red box of this space, in between something that's a pure legal framework and a pure market framework. That's where this squarely lies. So what today I'm going to talk to you about is not just we're going to talk about the TRI program and what has made it effective and what has kind of held it back. And in particular, what are some of the financial regulations that were subsequently introduced that made it more effective? Again, a lot of terms. If at any point, we're going to get a little technical into the accounting, but I have great pictures for that. So please don't be discouraged or too worried. Okay, but now let's talk about the TRI program. So the TRI program was introduced in 1986 following I think it was the EPCRA, the Community Right to Know, and it's a database at the facility year chemical level, where output is reported in pounds, so how many pounds of lead you produce. and by release type. Do you release that into the air? Do you release it into water? Do you release it into ground? And right now, the TRA program covers about 800 separate chemicals. And I really also want to emphasize that this is at the facility level. So this is at every individual establishment. So you can think of it as like, if it has an address, we'll know a company can have 10 facilities, but we will know the output by chemical, by facility for each of those individually. It's a mandatory reporting program. And the mandatory nature of it is it's dependent on the NAICS code, which is think of it as an industry classification code that exists, as well as the number of employees. You can think of it as basically universal. If you are producing any significant amount of chemicals, you're probably going to be covered. Like, I think you have to have more than 12 employees total in order to be required to participate in this program. And that means that every year, you go onto the EPA website. I presume that before the EPA website, you had to, print out a form or fax or something like that. And you fill in all this information. Now, the data has been accessible since 1989. It's currently available online, but back in the 90s, before the internet, it was available on magnetic tape and computer diskette. It was available at the National Library of Medicine, and the EPA actually took a number of steps to introduce this information and propagate it into the public sphere. So what does that mean? Like, they were contacting journalists. Investors were actually going and accessing this information. And they still do to this day. I believe actually this year is the 30th year of the TRI program. Okay, so the research question that economists ask, and this is not, and economists of many varieties, so these are people working typically in an environmental regulation, or environmental economics, but also people who work in financial regulation are interested in this because of some corollaries. But the major question, well, what was the impact of this program on the level of toxic releases emitted, right? Prior to the program being introduced, nobody really knew how many chemicals were being emitted by the individual facilities. After the program was introduced, now everybody has this knowledge. And the question is, what did investors choose to do with it? Non-investor stakeholders like community members, nonprofits, what did they choose to do with this information? And what kind of pressure did they exert on the firms themselves? It's kind of hard to answer this type of question with good inference as an economist, because it's a shock that impacted everybody all at once. But the one good thing that happened in this is that technically the data was collected starting in 1986, but it didn't become available until 1989. So what that meant is that between 86, 87, 88, that represented when the information was being collected but was not known by the broader population of investors and non-investor stakeholders or whatever. And then starting in 89, it became available. And so if you actually compare the toxic chemicals from the period of 86 to 88 and then 89 to 93, there's evidence that this led to a 13% reduction in pollutive output. So simply, again, just asking firms to quantify this in scientific terms, that is in pounds and levels of toxicity, where it was being emitted, ground, air, or water, was enough information for those stakeholders to put pressure on the firm and force them to reduce their output. Now, how did this work? So when this information was released to the market, basically the process that was undertaken was something called peer benchmarking. So what you saw in the data is that in every industry, where industry is pretty narrowly defined, there was a best-in-class performer, and then it turns out that either the managers at the competitor firms or their investors were saying, well, why are we not as good as that other performer, as that best-in-class? And that led to updating like production techniques, or improve, abatement, a whole set of things. But the way that this worked was that it wasn't that they were assessing their absolute performance. They were being assessed on a relative performance basis. And that is associated, again, with a 13% decrease in pollutive output. So this is an example, again, of what I'm talking about in that red box, where you have a mechanism that's partly legal, right? All of this information was created by a legal framework, but the market takes that information and it's impounded into share prices. In fact, I was reading, there have been a number of papers that have been written about this, and the firms that had the highest stock price drop, these are publicly listed firms, obviously, and this program actually applies to both publicly listed and private firms. But the publicly listed firms that had the highest stock price drop are the ones who reduced their output the most. So again, they're really feeling that pressure from investors. So this whole idea of disclosure as the dominant paradigm of environmental regulation in the market, that's what economists have come to understand. And I'm going to make the argument, I feel like it's the dominant paradigm of environmental regulation. I'm sure you all will correct me and tell me that I'm wrong. But I'm not sure if any of you are familiar with the U.S. Greenhouse Gas Reporting Program, but that is a very similar program to TRI. It was introduced in 2010. And again, at the facility level, firms are asked to report how many metric tons of carbon dioxide equivalent they emit. And again, that's just information put into the market. And there's a great scholar at SMU, it's actually a friend of mine, and he studies this and again shows that there's a modest decrease in the amount of metric tons of carbon being emitted because of benchmarking to peers. So this is again relying on the market to tell us how much of the pollutive output should be reduced. For those of you who have any experience in securities laws, I think it's very similar to the SEC's approach of let's just put as much information about the firm out there as we can in a 10K statement and let the market sort it out. And I'll just say that all evidence suggests that it is effective, but the results are modest. We're not seeing a huge change in pollutive output. So now I'm going to talk to you about what my paper is about, and that is financial liability recognition. So earlier, when I started this presentation, I said, well, if U.S. laws have governed this and said that if you create and emit and contaminate a site, you create a legal liability. Well, technically, under accounting standards, that should also create something called a financial liability. And a financial liability is like what was in the title of this presentation, financial remediation liability. It's like how much does it cost to clean up the site that you contaminated, right? Is it $100? Is it $100 million? So now we're going to get into accounting 101. And I promise it's not going to be too bad. It's literally just this image. So I want to make sure we understand what a liability is. You can think of a balance sheet. Hopefully I really don't want to lose you guys in this, but a balance sheet as like a snapshot in time about a firm's financial state. And so on one side you have assets. This is all the stuff the firm owes. And on the other side you have liabilities. Anytime liabilities is less than your assets, if you owe less than you own, then that's difference is called shareholder equity. That's good. We want liabilities to be small. We want assets to be large, because then that means equity is large. And equity represents how much value the shareholders have tied up in the organization. So when you own Apple stock, you're basically saying this is what you own, a fractional share of this. So what does it mean when we say that there should have been a financial liability? Technically, anytime a firm was polluting and contaminating a site, they should have been writing that they had a liability to clean up the space. They were supposed to tell how much it would be to clean it up, and then put that there. When they would do that, obviously, it would reduce shareholder equity. And again, shareholders love equity. That's what they want. Okay, this makes them really happy. But as it turns out, 62% of the firms, as of 1993, that were exposed to environmental remediation liabilities were not recognizing them on their balance sheet at all. And the reason why is they said it's really hard to measure. It's really hard to tell you how much it's going to cost to clean up this river, clean up this building, whatever. So my research question kind of follows on this earlier work on the TRI and says, well, what effect does the recognition of environmental remediation liabilities in that financial statement I just showed you have on pollutant output when pollutant output is already publicly known? So my question is, well, if we can get firms, they've already told everybody how much they're emitting. That's public knowledge. But if we can force them to tell their investors how much it's going to cost to clean it up, does that lead them to reduce their pollutive output even more? And as it turns out, I'm really lucky, there was a regulatory or an accounting rule change that did force them to do this. And that is the subject of my paper. And so we're really getting into the nitty-gritty of the accounting now. But SOP 96-1, we really, we need to get some marketing people up in accounting because this does not sound at all remotely or exciting. But trust me, it's really cool. So SOP means Statement of Position. Again, not the greatest marketing, but what this regulation did, it was introduced, and it basically said to all of the CFOs out there, you're telling me you can't quantify the cleanup costs? Well, too damn bad, now you are going to do it. And how? We're going to tell you all the rules. This document, this thing is like 200 pages. Riveting read. I highly recommend. If you're looking for it, call me, and maybe we'll do like a book club. And it basically said, okay, if the litigation has commenced, or if it's been asserted, or even if it's probable, guess what? You need to identify this liability on your balance sheet. It says which kinds of costs should be included, like not just the direct cost to clean something up, but also employee compensation and legal costs should be included in the total liability. That the liability cannot be netted against recoveries, like any kind of insurance claims. Again, these are things that previously firms were using as an out to be like, oh, no, I can't estimate this number. It's too hard. Well, no, now you can. Everything has been decided for you. This is the rule book. And even if you can't give me a single point, you're going to give me a range. And you're going to figure out a way to put that on your balance sheet and identify it as a liability. Okay, so my question as the economist is, what should this do to pollutive output at the firm? Because now what we've done is we've taken something that was purely in scientific units, that is pounds of lead, which I can assure you no shareholder knows what the hell that means, that is not in their vernacular, and turns it into something they understand very well, which is dollars. And how much it's going to, eat into their equity. So there are a couple ways you could think about this. Well, first off is maybe investors were really smart, and even though everything was given to them in scientific units, they backed out the cost. This is not new information. There's a lot of evidence from other settings and even in environmental related stuff that even if the firm cannot tell you how much something costs, investors are pretty sharp. They will impound that information into the share price. And so maybe all of this information was already incorporated into their understanding of the firm's performance and financial position. I'm guessing probably not, right? It's hard. This is a hard exercise to do. The TRI is costly in terms of time and expertise. There's no denying it was being accessed by investors at the time, but not perfectly understood. And we also know from my field that market participants place a much lower valuation weight on information that's costly to process. Meaning if they have to do a lot of guesstimation in it, when they eventually calculate that final number, they don't weigh it that much. So my conjecture, and this is co-authored work with my colleague here, Ed Owens, also in the business school, was that these new liabilities, when they hit the balance sheet, they are easier to process because you've taken the units from pounds of lead to dollars, and that people being the investors will notice it, and then they will exert market discipline because they don't want their shareholder equity to decrease. And if that's the case, the firm's response could be to reduce pollution. But here's the rub. That's one way of thinking about how this might happen. But the alternate story, and what I was thinking was actually going to happen, was that now the firm is managing two signals to the market. The first signal, this is how many pounds of lead. The second signal, this is how much it's going to cost to clean it. The firm management has a choice about which signal to manage, right? So, or to minimize. One option would be, okay, we're not going to you don't have to minimize both. You could be like, okay, we're going to pollute and still put out lead, but I'm going to invest in cleanup technology that makes it much cheaper for me to clean this up. So I'm going to reduce the liability. I'm not going to reduce the pollutive output. And in which case, if you actually lower the cleaning costs enough, you could see an increase in pollution. So to me, that's what made this study super interesting. It's like we're forcing them to think about this in terms of dollar values. Well, what are they going to do? Are they going to try to reduce the cost of the cleanup, or are they going to reduce the offending activity? So now I'm going to talk to you about the data analysis part of this. And get into some causal inference to tell you that this is a long way of me saying, I don't want to just say statistics, right? I want to show you that I'm thinking about this, and that this, when I say that this is what's happening, I've kind of ruled out, other explanations. So let's take it step by step. Okay, so the EPA TRI, that is the spine of our data, so that's what I've been using. I bring in information about the firms from a data set called CRISP CompuStat. I also go back to the EPA to identify which chemicals are hazardous to humans versus just hazardous in general. I also pull some data from the EPA on pollution prevention, that is whether or not firms are reducing the amount of pollution they produce, or if they're just doing good recycling programs afterwards. So this is a very large data set. It's going to cover 1993 to 1998. Remember, 1996 is that SOP 96-1. That's when that rule change was introduced. I have a little over 3,000 firm years in my sample, 50,500 and so facility year chemical observations. And I'm also, I Windsorized the data, which is to address extreme values. We do this because when I use and again, hope I don't lose you here, when I do the generalized linear models, I don't want outliers to overly influence the parameters I estimate. Okay, so what does the data look like? Well, the usual suspects are in this data. Okay, I'm looking at the pollutive output of the following industries: the chemical industry, the food and kindred products industry, paper, plastics. These are the industries that are obviously required to report under the TRI program. And then I'm like, okay, I'm going to feed all of that data into a statistical model where I'm going to estimate pollution as a function of a whole bunch of variables, including an indicator for whether or not this new SOP 96-1 was in effect. So that's what treat SOP is. And then you can think of treat and SOP and post SOP as an indicator for whether or not the new accounting rule was in place. This analysis is done at an extraordinarily granular level. I do it at the chemical firm facility calendar year level, so I'm not aggregating anything up. For those of you who are familiar with this kind of statistical research, I'm using Poisson regression. And I'm using something also called fixed effects, which is where I'm trying to compare the firm to itself. So I'm saying, okay, I'm going to track the same facility chemical over this entire time period, and I'm going to compare it to itself in the pre-period and the post-period. I also control for a number of other firm-level covariates, meaning things that might impact the total level of production, including the market value of the equity, the leverage at the firm, and something called the production ratio, which basically tells you if that facility was turned on or off, right? Because what I don't want to capture here is like, oh, does pollutants go down because they just turned the facility off? I'm looking for a rate, or that's what I'm most interested in. And here's what I find. So we talked about how the TRI program on its own led to a 13% reduction. Well, relative to that, we get an additional 13% reduction in pollutive output following the introduction of a new accounting rule. And that's amongst all firms. If you look at the firms that were most impacted by this new Statement of Position 96-1, these are firms that wrote to investors like, oh my goodness, this is a big change for us. That drop is 28%. On top of everything that had already happened when the TRI program went live. Let's just focus on the bottom panel down here for a moment. So what I'm doing is I'm plotting the effect. and everything's benchmarked to the year 95. So let's think of our relative year. So in 93, 94, with those are confidence interval bars, the pollution level was the same as what it was in 95. What happens in 96 is we start to see the first drop. 97, it drops more. 98, it drops more, or it stays low. The confidence intervals here increase because we have fewer sample observations, and I can talk to you about that if that's something you're interested in. But here's my takeaway from this. This era, before SOP 96-1, no change in pollution. 96-1 is introduced, pollution plummets. And again, why does it plummet? It's because you took something that investors kind of understood, but not really, or they were trying to make use of, and you translated it into units that they did understand. So what are some other things I can tell you from my analysis? It doesn't really impact air pollution, probably because there is no real liability that is incurred if you pollute the air, right? It's kind of hard to define what that liability looks like. It impacts pollution to the ground and to water. That's where we see the biggest effect. Okay, so I'm talking to you about, the goal of this talk today was to say, well, what is it when you go to this middle area that's half legal, half market framework, what can it do? Clearly it can do something, but it's not a panacea, right? It's not solving air pollution for us right now. Which chemicals does it have the highest effect on? Primarily, it actually I was wondering if this was just going to be human chemicals that only impacted humans. But it turns out that there's a reduction in pollutive output for chemicals that impact humans and animals. So we don't have to seem to worry about that. The market solves for that. The market doesn't solve for air pollution, but it solves for that. Now, I'm going to ask, well, what's causing the decrease in pollutive output? I know it's not that they just are turning off the machines. The machines are still running. That was part of the analysis. But I want to understand, is this a case of waste management where they just collect the lead and put it in one place and technically it hasn't been emitted? Or is this a case of abatement, or where they're improving the production facilities? And as it turns out, it is primarily waste management. So this is the limitation, right? When you put these two forces together, what we're seeing is that it's not that these facilities are being revamped and suddenly we have incredible innovation and we're not polluting this. We're polluting, but it's contained and it's being managed through a waste management process. So not a panacea, but it definitely is moving things. That's what we see here. This is waste management is going up, but there's no change in abatement. One of the last tests I want to show you is, I keep talking about investors and that investors should care about this. At no point have I shown you that investors have done anything. Everything is suggestive that the investor intervened. This is my attempt to show you that investors cared, because I look at investor response to 10K filings that talk about SOP 96-1 and the liability. And what we see here amongst, which we'll call the ones that have the highest level of liability, their cumulative abnormal stock response is negative. So this is the cleanest. I wasn't there in the 90s. Watching them call management and be like, "What's going on?" They don't even have earnings call transcripts from this time period. So all I can look for are crumbs of evidence that investors were doing something, and I think a negative stock return is probably pretty solid evidence. So what I tried to highlight for you today is, again, how I think economists are contemplating environmental issues, and I can't really speak for all economists. Maybe I can just only speak for myself. But I think when legal and market forces work jointly, they have the potential to reduce pollution. And I think in ways that people were not anticipating. And I don't know if I had told you earlier today that I think changing an accounting rule would, save the planet, you probably would have thought I was a little crazy. But I think this is just further evidence that we need, when we design these kinds of tools, we maybe need to consider the user and translate it in a way that matters for them. What we know is that the disclosure of information in scientific units for sure has an impact. Just having the TRI program matters. It has a modest impact on environmental performance. When you translate the scientific units to dollars, there's an incremental change that improves environmental performance. And to me, I think the most interesting research in economics in this space right now is everything in that red box, where you have, again, the market and the legal forces working together. Other things that exist in this box, cap and trade, for example. I was reading a paper recently on the trading scheme in Europe, and one of the problems with that trading scheme was they priced the allowances too low. So that market's not working. Another thing you could study are taxes. I mean, that's kind of, most taxes are kind of the bread and butter of most public economists who study public economics. But the point is, there's a lot more to understand that's going on in the red box. So anyway, that's sort of what I have prepared for today. And I know that Brig is managing questions and the like, but if any of this is of interest to you or you want to talk about it, feel free to get in touch. That's my email address, and I'm going to take questions now.
Thank you. Thank you for that presentation. There are two related questions here, and if you want to ask questions, please go to slido.com, and in the empty space there, hashtag Stegner. Maybe while we have, for the time we have, one of our respondents mentioned that they had a hard time with numbers, and I'm just going to read this for your amusement, Sarah. So to assume that for the sake of our argument, that I've had a hard time following numbers, something's been true from high school. What should I take away from the numbers? But let's try to make this very applicable, focusing on a hypothetical situation. So another one of our commenters said, there's a lot of talk of overlapping with this conversation about conversations about data centers, water and energy consumption particularly. Maybe thinking about sort of the general principles that you pulled out from your research, how could regulations focused on information help address those challenges?
Yeah. Okay, so a couple things. I think firms being explicit about how much water or how much energy they're using for their data centers and where that water and that energy is coming from would be a huge thing, right? That would, I think right now a lot of it appears to be a black box. That's the first thing that I would talk about. Or if you really wanted to understand, like, information is revelation, right? That's like the first thing. The second thing would be, to the extent there are liabilities that are associated with this, like if they are messing up the water or whatever, then translating those scientific units, again, to a dollar amount. So I would say if you're going to talk about how many kilowatts of energy you're using for the data center, that's good, but maybe also say how much that costs in like raw dollar terms. And then likewise, if you're going to talk about how many gallons of water are being used, like if there's a way to translate that into something that investors would understand more. Now, water is interesting because water is very much an underpriced asset. We do not charge the appropriate amount for water. But that would be like my first thought, is that the more transparency you have, certainly it allows for dumb disciplining. Not all the disciplining, right? But we saw that from the TRI program, but there is some disciplining there. Now, when it comes to interpreting the numbers that I tried to show you, there are a lot of numbers, and they can be a little alarming. What I look for whenever I'm going through an analysis and I'm overwhelmed, I look for the sign and the magnitude. So I want to see, is it positive or negative, and is it a big or small number? And so when I look at this, for example, looking at low in treatment intensity, it's a negative number, and it's if I go to high treatment intensity, it's negative, and it's a more negative number, which means the effect is greater. So sometimes I think we can get, people can get overwhelmed by the numbers, but the sign and the magnitude goes a long way to giving you the intuition that you need.
Thank you. Thank you. That was nice of you to take that.
Of course.
Here is our next question. It feels like the pressure of costs on owners and investors is always probabilistically related to enforcement. Have you tried to tease out the effects of increased reporting versus increased enforcement? I'd imagine they'd happen concurrently.
Right. So so
Do you want me to read it again?
yeah, that's a really good question. So
This is a lot to take in. It feels like the pressure of costs on owners and investors is always probabilistically related to enforcement. Have you tried to tease out the effects of increased reporting versus increased enforcement?
Okay. So here's what's interesting. In this setting, enforcement really doesn't matter, because what matters is whether the shareholders feel like they're getting a decent return on their investment. The only enforcement that really mattered, so to speak, in my setting, in my study, was that firms were actually following the new accounting rule. And that is subject to like auditing assessments and the like. So in most settings, maybe in like or I guess most legal settings, you think a lot about enforcement, but in this case, the market becomes the enforcing mechanism. And so all we need to know is that the information exists, and then it's translated in values and numbers that the investor can understand. Now, of course, when the TRI program was introduced, if people were not submitting their emissions numbers or the toxic release numbers to the EPA, that would be a problem. Or if they were misreporting or underreporting, absolutely, that would be an issue. But once you start moving this into the dollar values, it's all about private contracting.
Does time play a role in your model? Often remediation costs occur years into the future, arguably beyond the time frame considered by many institutional investors. Does the time delay impact investor valuations?
Right, it would. And in fact, that was one of the reasons why management at firms was reluctant before SOP 96-1 to acknowledge the liability on their financial statements, because they were like, this is not relevant, we don't know how to measure it, and it's going to happen 20 years from now. What SOP 96-1 did was force them to recognize now a cost that they may not bear for 20 years, but they did have to recognize it now. And that, I think, was what partly made the regulation or the financial accounting rule so effective.
I hate to give any one ideas in Washington, but here's a question for you. We've seen the fragility of traditional command and control liability. We have seen even the Trump administration focus on dismantling valuing human lives. Has the administration focused at all on TRI? And if not, why not?
Okay, so to the best of my knowledge, I don't think that they've focused on TRI. I think what makes TRI really palatable is the fact that it's market-based.
Yeah.
I think that is something that a lot of people can get involved or on board with, especially because the market allows you arguably to do this let's just take a step back. Something like TRI, something like cap and trade, what makes it arguably superior than a pure legal remedy or framework is that if it's developed well, it should be efficient, right? It gets the worst offenders off the market. It penalizes the people who emit the most with the most dollars. And I think that that's something that's more palatable to a broader range of people of different political persuasions.
Okay.
Now, I wouldn't be surprised if there were potentially right now, the TRI covers like 800 chemicals. I wouldn't be surprised if there were efforts to maybe cull that list down, but I haven't heard of the TRI program being under threat. I do think that there has been more done about, I think that the greenhouse gas reporting program has been under far more scrutiny, though.
Thank you. Have you studied the trends you identified in your research into the 2020s? And if so, have recent policies, regulations, or trade practices trended in a different or in a direction similar to or against the SOP trend you identified?
My study was focused purely on this so that I had the best inference and I could look to see exactly what the impact of SOP 96-1 is. I haven't looked at the more recent time period, but certainly would be an interesting exercise.
Okay. Does the waste management versus waste reduction ratio change over time? does the lead time for the waste stream reductions, like improved scrubbers, mean that we'll have different effects over time?
Yeah, so I think that the question is, what is the definition of waste management? So if waste management just, there can certainly be a delay or lag if it takes a while to like put on scrubbers or whatever, or in some ways address your, actually let me take that step back. Waste management and recycling, I don't think involves any kind of change to the industrial productive process. That would be abatement. That takes a long time. My understanding of the waste recycling is that it's just making sure that rather than like taking all the chemicals and taking all the lead and dropping it in a stream, you put it in like a safe container. And so that I think doesn't have quite the same lead time. Now it's possible, I guess the point would be here, that if I extended the time horizon of the sample, that maybe I would see that there's an increase in abatement because it just takes a long time to like increase that technology. It's definitely something that I could do. But in terms of people taking things that were existing off-the-shelf technologies, we don't see that happening.
I know that we've talked to, you've mentioned the greenhouse gas emissions rules, and we have kind of a question, and I think it was asked earlier in the session, like what would analogous scheme of disclosure and financial ability look like in the realm of GHGs? But if you maybe just kind of think about greenhouse gases kind of more broadly, and what are some of the lessons that we might take either from that particular question or from your research specifically in thinking about GHGs?
Yeah, so, okay, I think the limitation of the greenhouse gas reporting program is that it's going to be most valuable for the peer benchmarking exercise. It's going to be like, how well am I performing as a firm compared to other firms in my industry? But because right now there isn't a liability that's attached to the emissions, like it's not like firms can be individually held responsible, I think that we might have kind of maximized on everything we can get out of the greenhouse gas reporting program from a, if you're looking at it as a means to reduce emissions. If it's just there to like track emissions, it has a lot of value, but whether or not it's actually going to continue to reduce emissions, I think the effects will be modest at best, simply because the only mechanism underlying that is peer benchmarking and not any kind of liability attached to it. And you know what's really interesting, when SOP 96-1 was introduced, there was a huge uproar saying like, well, if you start adding this environmental liabilities on firms, they're all going to go under. Like they're not going to be able to survive. There was a huge amount of pushback. That has not been the case. So I'll leave you with that.
Perfect. How does the current market's decoupling of price to equity affect polluters? Will there be weaker association in more recent years in the current market as PE ratios exceed 100? I don't know much. Sorry.
Okay, yeah, so I think the question is thinking about stock valuation and the extent to which the stock valuation seems to be more and more divorced from actual earnings and dividends that you could get, and whether or not that dilutes the impact of this. I mean, look, anytime you have stock prices that deviate from fundamental values that should be driven by what's on the balance sheet, it's a problem. And so certainly that should be something that kind of dilutes the effect of this, just because it looks like the book value of the firm is not tied to the share price anymore.
Okay. How does limited liability and the ability to declare bankruptcy affect whether companies actually pay these costs?
Can you give me the last part of the question again?
How does limited liability and the ability to declare bankruptcy affect whether companies actually pay the costs that are forecasted?
Yeah, so that's a much better question for the lawyers in the field about what exactly their liabilities can continue to be. I would defer that to the subject matter experts. I'm not an expert in bankruptcy law.
Yeah, that's okay.
I try to avoid it personally.
Yeah, a lot of us do. Can I ask you this? Can you comment on the power of information versus other public accounting economics tools? So that red box that you have, you put a bunch of things in those boxes. Can you just maybe highlight some of the big lessons from the field about what are the various...
Like the other kinds of tools that exist in the red box?
Yeah, also kind of in relation to the ones that we've heard about today,
yeah.
perhaps.
I mean, okay, so I think the most, and I haven't done much work on this subject, but cap and trade is fascinating to me. Because the idea with cap and trade is that you establish what is the permissible or allowable like emissions or pollutant level, and then you let firms sort out who gets to do that emissions. And so arguably, the firms that have the easiest time improving their industrial processes and reducing their pollutive output should be the ones to make that change first, and you'll get like the kind of the biggest bang for your buck. But like I alluded to when the little work that I've been reading about the European trading scheme is that part of the issue is I think you have to price the allowances correctly. So if you put too many allowances in the market and then they're not priced correctly, you don't get a good result. Again, I haven't done much work on that, but I think the idea of how do you set those things appropriately is super interesting. Information, the disclosure we talked about, tax, I think, like I said, is something that a lot of people think about, like a Pagovian tax. But that's what I think the problem with tax is not really politically feasible, right? I think part of the reason why disclosure and revelation as regulation is so popular is that it's easy for people to palate. But yeah, the predominant paradigm is the disclosure one.
Okay. Let me see. Here's a question. And a lot of ours come in as anonymous questions, but this is from Jay Stern. I'm an environmental chemist. Enforcement increases output costs. Response is to send pollution-causing activities offshore and not address the contaminants. I see shifting method to a more energy consumption using more resources. Please comment.
Okay.
Did you follow that?
Yeah, I think so.
Yeah,
so
great.
I think there's the question of like, what I'm assuming in this is a closed system, right? That if you're going to continue, this program, the TRI program, covers facilities in the United States. And I've been focusing explicitly on companies that are publicly listed. I think the concern is if you make it more costly for those, are you just going to move this offending activity to an unregulated market like private firms? I didn't show you this analysis, but that does not appear to be what's going on in the TRI setting in terms of it's not that we're shifting things from the public sector to the like publicly listed firms to private firms. Whether or not it's being offshored, that I cannot speak to because I don't have any data on that. But absolutely, if the system is not closed and there's the option to move it offshore, like firms will take advantage of that.
I have a couple of comments that I'll show you just afterwards, kind of just some definitional things that a listener wanted you to see. But just one last question then. So this has to do with the red box, and it has to do with also sort of comparative issues. How much does the red box rely on functioning markets and governments?
A lot. I mean, if you just think about the TRI program, you have to have like the TRI program has enforcement, right, in terms of making sure that people actually report, and then there have to be penalties for not reporting, and then on the market side, it has to be like a fair market, right? You can't have firms fudging their numbers. Absolutely, that matters a huge amount. That becomes foundational. What we know is that when you have functioning government, what you reduce are transaction costs in the economy. And the more you reduce transaction costs, the more you reduce something called dead weight loss, which means that this becomes more and more efficient. So maybe you would still see some of this happening, but it would not happen to the same extent because it would be crowded out by the transaction costs. Now, what is the sufficient amount of government and functioning that we need? That's another paper.
Well, I just want to thank you one more time. Let's give Professor Malik another round of applause.
Thanks for having me.
Just one last reminder, we have an upcoming, the Wallace Stegner's 31st Annual Symposium, America's Public Lands at a Crossroads, will be held on March 19th to 20th. Registration is open, so please reserve your spot. Thank you all for coming. We really appreciate you being here.
Thanks, everybody.